Good morning again. For anyone that missed my name, I am Katherine Sandoval. I am a senior associate in our California office of Mattison, Wickert, and Lair. So this is going to be an overview covering some advanced concepts of California workers' compensation subrogation. And again, I wish I could cover these topics in even more depth than I'm covering them, but there is just such a huge amount of information on these subjects. This is part of a two-part series. I gave part one about a month ago. So if you were unable to join for part one, it is available on our website. And let's go ahead and dive in. So I wanted to provide you with a roadmap so you can see how this presentation is going to flow. We're going to start with employer negligence, and we are going to talk about employer negligence actually most likely in almost every single one of these other topics because it's such a relevant issue to discuss. We'll move to allocation of the third-party recovery. We'll talk about attorneys' fees and cost allocation. We'll also talk about the jurisdiction of the W.C.A.B, also known as the Workers' Compensation Appeals Board. We'll talk about future credit, waivers of subrogation, and then we'll end with just some information on staff leasing and temporary employee services. As Jamie mentioned, we should have time for questions at the end. If not, I will respond to your questions via email. Employee negligence. It is very important to distinguish what the defense is going to argue in your case. Are they arguing employee negligence or employer negligence? You must determine that because it will affect your lien depending on what type of negligence the defense is going to argue. So negligence of the employee reduces the employee's gross recovery, but it does not reduce the subrogation interest of the employer carrier. And I may interchange between the employer or the carrier throughout this presentation. So in Kremer versus Challenge Milk Company, the court found that an employee's contributory negligence in causing an injury is not attributed to the employer and will not reduce the subrogation interest or reimbursement rights of the carrier employer. And this is so important because many defense counsels believe that employee negligence is going to reduce your subrogation lien, but it does not. And you really need to be ready to educate defense counsel of that. They are very, very confused with the difference between employee negligence and employer negligence. So does it affect the subrogation lien? Well, if the employee is negligent, then it is and it can reduce the settlement pot if defense decides to settle globally with all the parties. And we'll look at many examples throughout this presentation of how that's going to work. Now, employer negligence. This is what will affect a subrogation lien prior to any settlement. It has been known in the field as the Whitby-Jackson defense when the employer negligence is raised. You'll typically see this as an affirmative defense in an answer, but it can be alleged at any time during the pendency of the case as discovery continues. So more and more, I've started to notice that the defense isn't raising it as a defense outright. They're not labeling it in the pleading as a Whitby-Jackson defense, as you may have seen previously. It sometimes is raised as a very vague defense, and then sometimes it's not raised until something's discovered in the discovery phase. I have tended to see defense start to raise it during depositions. So how can it be raised during a deposition? Well, you will see the defense begin to ask questions when they are deposing the employee. somewhere along the lines of, what safety training did you receive? How long was this training? Were there any safety videos? How long were those safety videos? Did you take any safety courses? Did the employer provide retraining? Or sometimes you may receive a subpoena or you may receive discovery questions where they're asking the employee for their safety training manuals. Defense is likely trying to point out that the employer somehow failed in their aspect of training the employee, and that is why the employee got hurt, not because of the defendant. So whenever I see those lines of questioning occurring in a deposition or in discovery, a light bulb goes off in my head saying, I think they're trying to raise employer negligence. I need to be wary. So always be on the lookout regarding employer negligence. Now, what happens when the employee is the only one that filed suit, not the carrier, and then the defendant raises employer negligence? Well, the employee is required to give the employer notice that this allegation has been raised. I would recommend that the carrier check with their insured regarding if they've ever received this type of notice. I have seen it that insurers forget to tell their carrier. So always just check with your insured. And we are now at poll question number 1. Employee negligence will reduce the carrier's lien. True or false? And I'll give you guys about a minute to respond. Okay, so we have about 85% of the vote in. I do just want to remind you that the answer is false. So employee negligence does not reduce the carrier's lien. It can reduce the total settlement pot, but the lien will not be reduced by employee negligence. So allocation of third-party recovery. A carrier is subrogated to and or entitled to reimbursement from the entire judgment or recovery in the third-party case. And California Labor Code section 3856 lays out a pretty good roadmap here on how allocation of a third-party recovery is to be allocated between the employee and the employer. So I want to take a look at different scenarios and what the recovery is according to the California Labor Code. So if the carrier sues alone, pursuant to California Labor Code section 3856, subsection B, it provides that the third-party recovery is going to be allocated as follows. It's first the reasonable litigation expenses and attorney's fees. Then it's the carrier is reimbursed for any compensation benefits or special damages it has paid under California Labor Code section 3852. And then any excess is to be paid to the employee. Now, I want you guys to remember a couple things. The excess cannot be pocketed by the carrier. And another important thing to remember is that the excess that is paid to the employee also becomes a future credit in the claim. And this is important for when we discuss future credit. Now let's look at if the employee sues alone. The allocation of that third-party recovery is as follows. It is, again, the reasonable litigation expenses and attorney's fees are paid first. Second, it's on application by the carrier. A first lien is allowed for the employer's payment of compensation benefits and special damages that are allowed under, again, California Labor Code Section 3852. And then any excess goes to the employee. But remember, the carrier is going to be responsible for a pro rata share of the employee's attorney's fees and costs of litigation. And we will go into this in much more depth when I talk about attorney's fees and costs. Just so you guys have a ballpark, typically fees and cost reduction that you're looking at is roughly somewhere between 1/3 to 40%. Of the lien. I've seen it as high as 50%, but it's typically around that 33% to 40%. Now, if both the carrier and the employee sue together, then they can be represented by the same attorney or by separate attorneys. The allocation of the third-party recovery is going to be as follows. Again, reasonable litigation expenses and attorney's fees are paid first. Then the carrier is going to be reimbursed for the amount of workers' compensation benefits or special damages under California Labor Code Section 3852. And then any excess is going to be paid to the employee. An employer or carrier that's seeking reimbursement, though, must first pay workers' compensation benefits in an amount equal to the employer's own percentage of fault multiplied by the injured worker's total civil damages before it may recover any remaining portion of its lien from a defendant. And this is what's been called and known as this employer negligence threshold. An interesting part of a third-party settlement is that there will not be a finding of employer negligence because there's been a settlement. So where there's no adjudication or determination of the percentage of negligence of the employer, such as in a settlement, the plaintiff has not established, I'm sorry, it's not the plaintiff, it's the defendant has not established that burden of showing that the employer has engaged in tortious misconduct so as to bar recovery of its lien on settlement proceeds. Therefore, in this scenario, there should be no employer negligence. But there's a flip side to this. If the carrier has their own case pending and a settlement is between the plaintiff and the defendant, and the plaintiff, as part of the settlement, decides to defend and indemnify the defendant against the carrier's suit, well, the plaintiff is trying to force the carrier to bend to their will because the plaintiff then is stepping into the shoes of the defendant and can begin to argue and allege employer negligence on behalf of the defendant. And that doesn't bode well sometimes because obviously the employee will know all about what's going on with the employer. So in these next couple slides, we're going to go through some examples, and I've tried to keep them simple with just the court awarding damages. Okay. So this is a good example of how an employer threshold will have been met by the past benefits that have been paid and then what the employer is allowed to recover. So in this example, the employee recovers $100,000 at trial. That's what they're awarded. The employee is also found to be 20% at fault. Now, the employer is found to be 10% at fault, and that would be considered the employer negligence. The employer's workers' compensation lien is $20,000. And let's say the defendants are 70% at fault. So first you need to determine what the gross recovery by the employee is. And here it's going to be $80,000 because although awarded $100,000, he was found to be 20% liable. So you're going to multiply the $100,000 by the 20%, and that gives you $20,000. So therefore, then you're going to subtract 100,000 minus 20,000, giving the employee that gross recovery of $80,000. Now that you've calculated the employee gross recovery, you then can move on to the employer threshold calculation. Remember, you do need to determine that employee's gross recovery first. So the employer threshold is then going to be calculated by taking the gross recovery of the employee, $80,000, and multiplying it by 10%, because that was how much the employer was found to be at fault. Therefore, that employer's threshold is $8,000, right? 80,000 times 10% is 8,000. Now then, what is recoverable for the employer? Well, the employer threshold was 8,000. So in other words, that means that the employer must first pay $8,000 prior to any recovery on the lien. So if we look at this example, the past benefits that were paid were $20,000. But now you have to subtract that threshold because you cannot collect on the amount of the threshold. So you subtract 8,000 and you get 12,000 as recoverable benefits. So you can see in this example, there was still employer fault, but there was still a recovery that they were able to make. Now let's go to example 2. This is a good example of when a past lien will get completely wiped due to such a high employer fault threshold. So in this example, almost similar facts. The employee recovers $100,000 at trial, and by recover is awarded. The employee is found to be 0% at fault. And let's say now the employer is found to be 30% at fault, giving them that employer negligence. And the employer's workers' compensation lien is still that $20,000, and the defendant is still 70% at fault. Again, you need to first determine what the gross recovery by the employee is. And this one's simple because there was no employee fault. So the gross recovery by the employee is $100,000. So the employer threshold is then calculated by taking that gross recovery of the employee, which in this scenario is $100,000, multiplying it by 30%, as that is how much the employer was found to be at fault. Therefore, the employer threshold in this case is $30,000, the 100,000 times the 30%. Now then, what's recoverable for the employer? Well, this threshold is 30,000. So if we look at this example, the past benefits that were paid was 20,000. And if you subtract it, you're now getting a negative $10,000. So the lien is completely wiped out and the carrier is not entitled to recover on their past lien. And let me walk you through one more example. And this is an example of where there's no percentage of employer fault, but there is employee fault. So again, similar facts, employee recovers or was awarded that $100,000 at trial. The employee is found to be 30% at fault, and the employer is found to be at 0% at fault. So no employer negligence was found. The employer's workers' compensation lien is $20,000, and the defendant is, again, 70% at fault. So again, we first determine what the gross recovery by the employee is. And it is going to be $70,000 because although awarded that $100,000, the employee was found to be 30% liable. So you multiply $100,000 times the 30% and you do get $30,000. Therefore, when you subtract the $30,000 from the $100,000, it gives the employee a gross recovery of $70,000. Now, the employer threshold is then calculated again by taking that gross recovery of the employee, which is $70,000, multiply it by that percentage of fault on the employer. Well, in this case, since there was no employer fault, the percentage is 0, and then the employer threshold is 0. So now, what is recoverable for the employer? Well, that employer threshold was $0. So the employer is still entitled to $20,000, the entire amount of its lien. So this is also a very good example of showing you what I was talking about as the employee negligence can reduce the settlement pot. So the settlement was originally, or the recovery was originally $100,000. But due to the employee's negligence, it was reduced to $70,000. And this also shows you that the employee negligence did not touch that workers' compensation lien. So with all of these examples I just walked you through, you can see how important it may be when there is this allegation of employer fault. Now, I want to talk to you about the jurisdiction of the W.C.A.B. The W.C.A.B. stands for the Workers' Compensation Appeals Board. So California Labor Code Section 5300 sets forth the jurisdiction of the W.C.A.B., such as the W.C.A.B. has jurisdiction for the recovery of compensation, or concerning any right or liability arising out of it. Also has jurisdiction for the enforcement against the employer or an insurer of any liability for compensation imposed upon the employer. They also have the jurisdiction for the determination of any question as to the distribution of compensation among dependents or other persons. So the W.C.A.B. has exclusive jurisdiction for workers' compensation benefits. And this is so important to remember when it comes to applying for future credit. And I also want to make sure that we are all on the same page as to what can be awarded. So the Superior Court cannot award workers' compensation benefits, and the W.C.A.B. cannot award damages for injuries. So the W.C.A.B. has this exclusive jurisdiction to determine how proceeds of any settlement are going to be allocated between the employee and the carrier, which necessarily involves addressing the employer negligence issues, the validity and extent of a carrier's lien, and the apportionment of attorney's fees and litigation costs. But once suit is filed, the Superior Court has jurisdiction, and it's theoretically concurrent with that of the W.C.A.B. unless and until the court is divested of jurisdiction by a dismissal of the civil action. So how does it work with the interplay of the superior courts, the state courts, the federal courts that are dealing with the third-party case and the W.C.A.B.? Well, the court's determination of employer negligence is binding on the W.C.A.B. as long as that issue was raised in the civil action. So only a third-party defendant may raise employer negligence in the civil action because of the exclusive remedy rule. So a finding of the employer negligence by the W.C.A.B. is not binding on the superior court because the third party defendant is not a party to the workers' compensation case. As a practical matter, the issue of employer negligence, I have really never seen raised in the W.C.A.B. prior to the resolution of the civil action. You typically will see the employer negligence raised in the W.C.A.B. when you're dealing with that petition for future credit, and there's no finding in the courts. So we are now at poll question number 2. W.C.A.B. awards workers' compensation benefits and the Superior Court awards damages for injuries. True or false? And I will give you guys about a minute to respond. Okay, and the answer is true, which most everyone got. Great job. I want to go in depth a bit more about attorney's fees and costs and allocation. If you recall from a couple slides before, each allocation started with attorney's fees and costs. And California Labor Code section 3856 and 3860 address the allocation of attorney's fees between the employee and the carrier. So under California Labor Code section 3856, the passive beneficiary is going to have to bear a fair share of the litigation cost. This is important because this also is going to apply even when both the carrier and the employee have retained separate attorneys and both have filed suit or one has intervened into the other suit. So California Labor Code section 3856 measures the priority of the employee's attorney's fees over the workers' compensation lien. And it considers 3 situations which determine how these attorney's fees and costs are going to be allocated based on who prosecutes that third party action. So in the first scenario, if the action's prosecuted by the employer carrier alone, then the litigation expenses and the attorney's fees are based solely upon the services rendered by the employer's attorney in effecting the recovery, both for the benefit of the employer and the employee. That makes sense. Same will go in the second scenario if this action is prosecuted by the employee alone. The litigation expenses and the attorney's fees are based solely upon the services rendered by the employee's attorney in effecting that recovery, both for the benefit of the employer and the employee. The third scenario is if the action is prosecuted by the employer and the employee jointly. Well, litigation expenses and attorney's fees are actually based solely upon the services rendered in each instance by the attorney in effecting recovery for the benefit of the party represented. In all 3 of these scenarios, the fees are deducted off the top. And under California Labor Code section 3860, it contains provisions affecting the apportionment and responsibility for litigation expenses and attorneys' fees. So what does this all mean? Courts are looking to see, did each party, did each counsel actively participate in the generation of the settlement. If a carrier actively participates in the procurement of that third-party recovery, apportionment is appropriate. So some factors that the courts have looked to are, did the carrier attend depositions? Did the carrier attend the deposition and participate in the deposition? Did the carrier consult with experts of their own, or even with that of plaintiff's counsel? Did the carrier present any evidence? Did the carrier deliver any arguments during trial? Merely showing up at a deposition or filing one or two documents, like just the motion to intervene, is not going to cut it. The court is looking for substance that the carrier provided to the case in order to effectuate settlement. So in general, an employee is entitled to attorney's fees as long as there is no active participation by the carrier in the third-party litigation. So when a carrier's attorney and an employee's attorney are both actively prosecuting the action against the third party and it results in a settlement, the fee for the employee's attorney must come out of actually the employee's share of the recovery. So what's the takeaway here? Well, I personally like to always issue maybe a small set of my own discovery if there's been a lot of discovery. If there hasn't been a lot of discovery that's gone on in the action when I've intervened, I will do a good amount of discovery in a case. Also, I attend every deposition, or at least I try to, depending on my schedule. Pre-COVID, in order to save costs, I would attend telephonically if the deposition was not of a critical deponent. During COVID, everything being via Zoom, it is easier to attend every deposition in person since you can still do it from your home or your office. I also attend every hearing just to make sure that the judge knows I'm present and also to get my name on the minutes. And this may include motions that don't actually involve me. And sometimes I tend to take the reins in organizing the mediations, the arbitrations, getting them formally set up. I have found that really inserting myself when and where I can, but also being mindful of cost, has closed plaintiffs' counsel's doors on this active participation front argument that they always like to add right at the end when the settlement is being divided. Now, I want to give you an example of attorney's fees, employer negligence, and how that works. So, similar facts to the last example. Employee is awarded $100,000 at trial. The employee is also to be found 20% at fault. The employer is found to be 10% at fault. Again, that employer negligence. The employer's workers' compensation lien is at $20,000. The defendant is 70% at fault. And the employer did not actively participate and needs to also pay their share of fees and costs of, let's do it at 1/3. So the gross recovery by the employee is going to be $80,000 because you reduced it by the 20% fault. So the employer threshold is then calculated by taking that gross recovery of the employee, $80,000, and multiplying it by 10%, as that's how much the employer was found at fault. So that threshold is $8,000. So the recoverable benefits are $12,000. You do 20,000 minus 8,000 is 12,000. But you then also have to remember the employer did not actively participate. So you also need to then subtract another 4,000 in this case, a third of the recoverable benefits. So really the recovery is now $8,000. So it's always important to actively participate or you're going to lose a portion of the fees that you may not have needed to lose had you been participating actively. Future credit. I interchange them. This is always a fun topic to discuss. So California Labor Code section 3853 and 3861 provide for and define a future credit for carriers upon resolution of a third-party action. The carrier is entitled to a future credit in the amount of the net recovery by the employee in the third-party action. And what does net recovery mean? It means after payment of expenses or attorney's fees. It's whatever the employee gets to take home. Because you'll typically see in a scenario where, let's say it's $100,000, you have $50,000 to the carrier and then $50,000 to the employee. But that's not the employee's net recovery, because from that $50,000, they have to pay their own attorney whatever fees they've agreed upon. So let's say it was, 50%, making these numbers easy. The net recovery there is actually $25,000, not $50,000. It is extremely important to remember that the past lien reimbursement and the future credit are separate and distinct. Credit is going to be distinct from the lien because the carrier cannot recover for benefits that have yet to be paid. You would not believe the amount of times I've had to educate a plaintiff's counsel regarding their confusion on reimbursement on a past lien versus future credit. If a carrier settles its claim for reimbursement of past benefits by compromising its lien, this does not affect its right to obtain a credit for future benefits. Why? Because the carrier, in its independent action against the third-party tortfeasor, cannot recover workers' compensation benefits that have not yet been determined by the W.C.A.B. The lien allows the employer to be reimbursed for money already paid. Credit is taken against sums which may become due in the future. So, can a carrier lose their credit rights? Only through an express waiver of that credit. It's not just because you settled the past lien. And even if you did not settle the lien, and you may have waived the lien, or the carrier may have failed to assert the lien in a third-party action, it does not constitute a waiver of the future credit. So who determines the future credit rights? The W.C.A.B. does, not the courts. And the W.C.A.B. will take some facts that were found in the courts in making a determination on future credit, such as the amount of the employee's total damages, respective fault of the parties. If the issue of employer negligence has been judicially determined, that issue is binding as res judicata on the board. So if the issue of employees' total damages was never determined by the court, then the W.C.A.B. will make that determination. And that is never good for a carrier or an employer, because the W.C.A.B. is ultra friendly to the employee. Note that in some instances, the W.C.A.B. has called plaintiff's counsel in from the third party case to a hearing to ask about evidence of employee damages. So I want to take an example. We're going to do example 5. And again, employer negligence is rearing its ugly head when it comes to future credit. So let's walk through this example. It's different than the other ones. It's different numbers. So it has been determined that the employee's total damages are $1 million. The employer's lien is $175,000, and the employer is found to be 20% at fault. The defendant is 80% at fault. So the defendant only pays for 80% of the total damages, which is $800,000, right? 1 million. You're going to do that calculation there. So now we look to determine what is the future credit threshold. What is the amount that must have been paid prior to a future credit being asserted by the employer? Well, the employer was found to be 20% at fault. So you take the employee's total damages and multiply it by 20%. So 1 million times 20% is 200,000. Therefore, that credit threshold is $200,000, which means that in order to assert a credit on the employee's net recovery, the carrier must first have paid $200,000. So in this case, the employer's lien was $175,000. The employer still must contribute an additional $25,000 prior to asserting the future credit. Well, I think your question may be, well, what future credit are they entitled to? Let's take a look at example number 6. So in this example, the employee's settlement in the third party is $3,400,000. In this case, the employee's damages were not determined by the court. Very important. So the employee nets $100,000 after paying the attorney's fees and expenses. And the employee's lien is $75,000. So in this case, the employer's negligence was not determined in the third-party suit. Important. So then the employer wants to assert a credit on that employee's net amount. Well, the W.C.A.B steps in and now makes this determination that the employee's total damages is $500,000 and the employer fault is 25%. So continuing with example 6, what is that credit threshold? We have to go by the values that were determined by the W.C.A.B. And the employer was found to be 25% at fault. So you take the employee's total damages that was found by the W.C.A.B. and multiply it by 25%. So 500,000 times 25% is 125,000. Therefore, the credit threshold is 125,000, which means that in order to assert a credit on the employee's net recovery, the carrier first must have paid that 125,000. So in this case, in this example, the employer's lien was 75,000. The employer still must contribute an additional 50,000 prior to asserting the future credit. So then how much credit are they entitled to? Well, you take the net worker's amount of 194,000 minus the credit threshold of 125,000, and the carrier will be entitled to a future credit of 69,000, but cannot assert it again until they have paid that additional $50,000. So how do you claim a credit? A petition should be filed with the W.C.A.B. seeking an order setting out the employer's right to a credit against its future workers' compensation liability. A petition for credit must be filed if an allegation of employer negligence has been alleged. So this petition is typically filed by the carrier's counsel in that workers' compensation claim. Typically, the workers' compensation attorney will request the net value from the subrogation side because that's who will have that value available. Now, according to Skiff versus the W.C.A.B. Brown, they said that it's not necessary for a carrier to file a petition for credit in a case where there's no employer negligence. I just always heed this warning that if there is even a suggestion of any employer negligence, always just file that petition. As I mentioned earlier, the W.C.A.B is pro-employee, so just always be aware that if that employer negligence has not been determined in the third-party action. Now, remember, the carrier's right to reimbursement of past benefits is separate and distinct from the carrier's right to a future credit when the plaintiff makes a recovery. So where the employee settles around the carrier is still entitled to a future credit. So just remember, the employee can still challenge the right to a future credit by arguing employer negligence to the appeals board. And if an employee doesn't settle around the carrier, but makes a settlement against a third-party tortfeasor without perhaps the participation of the carrier, a credit for any net sums received by the employee can be applied as future credit as well. And I talked a lot about settling around in part 1. Now, I do want to talk about third-party compromises and releases. So a third-party compromise and release is when the workers' comp claim is still open, and there's also this active third-party action. A third-party CNR, as it's called, will settle and close out both that workers' compensation claim and the third-party action. It sounds very easy, but you do need to have the involvement of the Workers' Compensation Council, the Applicants Council, when you do a third-party CNR, as there's many moving parts within a work comp claim. So as you can see, the carrier is going to benefit a lot with the third-party CNR. They're going to get to deal with getting some, maybe possibly some reimbursement on the past lien, and they're going to also be able to close out any future payments by closing out a work comp claim. But what's the benefit to an employee then? Well, instead of having to deal with a potentially massive credit, the employee can get paid out something potentially in both claims and also be done. So I want to walk you through what a third-party CNR would look like. It's a very simple version. So first, you need to look at the third-party settlement so you can see how much credit is available. So in this example, the third-party case settlement is $500,000. Of the third-party settlement, the carrier gets $130,000 on the past lien. Plaintiff's attorney's fees are $160,000. So the employee's net is at $210,000. So that net recovery to the employee of $210,000 represents the maximum potential credit available to a carrier against future benefits in the workers' compensation case. So then you turn to the work comp claim. You know the employer has this large future credit of $210,000. So then this is where the applicant's attorney and the defense work comp attorney come in, because they need to help figure out what is going to be the CNR value of the work comp claim. So let's say in this case, it's come to an agreement that the CNR value is $175,000. So does that mean that the carrier is going to have to pay another $175,000? No. This is where future credit comes into play. You can use part of the future credit to put towards that CNR value. Now, one may ask, well, why not put all that $210,000 worth of credit towards the CNR value? And that's a great question. The reason being, you will notice on this example that the applicant's attorney's fee needs to be paid, and you have to provide actual money for that portion. In addition, you do need to give some sort of value to the employee in the CNR, because remember, all the parties can agree to a CNR, but it's the W.C.A.B judge that has to wind up approving it, and a W.C.A.B judge is going to be looking out for the well wishes of an employee. So in this example, there's $175,000 CNR value consisting of $35,000 in new money. from the carrier, and then we're using $140,000 in credit from the third-party recovery. So it constitutes a waiver of $70,000 in available credit, right? The 210 minus 140,000 is 70,000 that we've waived. The applicant's attorney's fees typically are about 15%, and they're to be deducted from the 175,000 CNR, which is comes out to $26,250. So the net cash payment to the applicant for the workers' compensation case is $8,750, right? You have the $35,000 in new money minus the applicant's attorney's fees. Therefore, the combined amount the employee will be receiving as a recovery for both that third-party case, the $210,000, and the workers' compensation case, the $8,750, is $218,750. Waivers of subrogation. So contractual provisions agreed to by an insured may be enforced against an insurer, even though the insurer was neither a party to the underlying agreement or in privity with the party seeking to enforce those provisions. I spoke about this topic in regards to contractual indemnity provisions in part 1. Waivers are typically found in contracts. Therefore, you should read any contract between your insured and the tortfeasor to make sure that there are no waivers of subrogation, because waivers of subrogation are very well recognized in California and are enforceable. I do want to state, though, that you really do need to read these waivers very, very carefully. I recently had a case where defense insisted that there was a waiver. So I read through the waiver and they were correct, there was. But the waiver was specific to property damage and bodily injury only. In my particular case, we also had damages as to lost profits, which I argued was not covered under the waiver. And they agreed. And so we were able to pursue those damages. And again, I just want to make sure that this is ingrained, is that waivers of subrogation do not affect the future credit rights because they're separate and distinct. And we are on poll question number 3. When a carrier waives their past workers' compensation lien, the carrier also waives the right to future credit. True or false? Give you guys a little time to respond. Okay, and we have about 85% of the vote in, so the answer is false. So our last topic for this presentation is staff leasing and temporary employee services. It is important to get the definitions down first. So an employer is described as any person having direction, management, control, or custody of any employment, place of employment, or any employee. And you can find this definition in the California Labor Code section 6304. A general employer is typically the one that is lending its employee to someone, and that someone is being that special employer. And as long as the employee consents to this change in employment, the employee becomes a borrowed servant of the special employer, and it's what's called a special relationship has been created. And when this occurrence happens, the general employer relinquishes to the special employer all right of control over the employee's activities. So under the general borrowed servant law, an employee is barred from suing either his general or special employer by the exclusive remedy rule. So what is this special employer relationship? Well, the existence of the special employer relationship must be determined based on the particular facts of the case. No two cases are alike, and it's also a case-by-case analysis. It's important to note that it is the reality of the situation, not the party's characterization of the relationship, that controls this outcome of the analysis of that particular employment situation. So on this slide, you'll see that there's many different elements that various elements that are considered to determine if there is such a relationship that does exist. Now, California Insurance Code section 11663 really does spell out who is liable for what. So as between the insurers of a general and a special employer, one which ensures the liability of the general employer is liable for the entire cost of compensation payable on account of injury occurring in the course of and arising out of the general and special employments, unless that special employer had the employee on his or her payroll at the time of injury, in which case the insurer of this special employer is solely liable. And California also has some specific laws with regard to employee leasing and staffing agencies and temporary employee situations. Generally, an employee leasing firm and its clients are both immune from third-party suits, provided that an employee leasing agreement has been executed and there's insurance coverage for the worker that was remained in effect throughout the length of the employment. So when an employee leasing company or a staffing agency lends one of its employees to another company, and both have that right of exercise control, the right to exercise control over this dual employee and his work, a special employment relationship arises, and this dual employee is considered to be a borrowed servant of the general employer engaged in dual employment. And just so you guys, I wanted you guys to just be aware of this, that on January 1st, 2015, California did pass a law that increased the liability for employers using staffing agencies or other labor contractors. It's California Labor Code section 2810.3. It does contain 3 new requirements. And they are that an employer must share with a labor contractor all civil legal responsibility and civil liability for all workers. That an employer cannot shift to a labor contractor any legal duties under the provisions of Cal OSHA, and that they do have to provide a state enforcement agency with any documents to show that they're in compliance with state laws. It isn't applicable, though, to small employers with who have fewer than 5 employees or with a workforce of less than 25 workers, including those obtained from a labor contractor. So I know I went through a lot of information. We do have a book available that covers workers' compensation subrogation, not only in California, but all 50 states. As well as it does provide you with general information about workers' compensation insurance subrogation. It's a wonderful resource, and it's available through the Juris Publication website that's shown on our screen, as well as at our website. Now I have a very little bit amount of time. I'll try to answer 1 or 2 questions. Again, I will get an email of all your questions as well. If you think of other questions later in the day, tomorrow, this screen does have my contact information. So quickly, let me just do 1 or 2 questions. Let's see, I have a question here from Amanda. It says, you spoke on attorney's fees and costs. How can you confirm what plaintiff's attorney's fees are? That's a good question. So if it's something above that standard 1/3 that they're asking for, I typically will ask for plaintiff's counsel to provide the contract between them and the injured employee. I do inform them that they obviously can redact all the sections besides the fee arrangement so I can verify it. In practice, I've seen it, as I said, typically as high as 40%, but I've seen 50%, which I think is crazy, but I did verify it. So, and then I'll answer one more question, a question from Alex. Okay. When you petition for credit, who has the initial burden of proof? Oh, that's a good question. Okay, so the carrier has the initial burden of proof to establish that it's right to that credit by showing it's paid benefits and that there was a third-party settlement. And then what happens is the burden shifts to the employee to then establish that the employer was negligent. So once that is done, then the burden shifts back to the employer carrier to prove comparative fault by the third party and or the employee. Thank you again so much. I appreciate your time. Have a wonderful rest of your week.